didn't even look, didn't see him there. All right, this is Dominic Wesselo. You Dominic Wesselo?
Yes.
Is that how you pronounce your name, Wesselo?
Yes.
All right. This is, Ben, could tell Marcia I need a 2024 sheet. This is case number 23 CR 223, State of Ohio versus Dominic Wesselo. Mr. Wesselo, you were indicted by the grand jury on December the 5th on a charge of aggravated possession of methamphetamine, a fifth-degree felony. It alleges that the offense occurred on or about July 26, 2023 in this county. At that time, you did knowingly obtain, possess, or use a Schedule II controlled substance, methamphetamine. That's a fifth-degree felony, which, if convicted, carries a possible prison term of between 6 and 12 months, a fine of up to $2,500, and a possible license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you. If you cannot afford to hire one, the court will appoint one for you. And I see you have filled out a financial disclosure form. Everything on that form correct?
Yeah.
And when was the last time you were employed?
It's been a good year, so.
All right. Court will find that you are entitled to appointed counsel. I'll appoint attorney Sarah Barger of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. We will set your first pre-trial for February the 21st at 1 p.m. The final pre-trial will be set for March the 6th at 2 p.m. Actually, both of those will be at 2 p.m. The 21st of February will be at 2 p.m. as well as March the 6th. And your trial date will be March the 28th at 8 a.m. Now, you've never been convicted of a felony, is that correct? All right.
That's correct.
Well, I'm going to grant you no R-only bond, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that, regardless of what happens in this case. You'll be required to pay a deposit of $171 within 30 days of the clerk to cover certain statutorily required fees. You'll be under pretrial supervision of the probation department on 117 East Main Street in Hillsborough. Do you know where that is uptown here?
Yes, I do have a question about that. If I already have a probation officer in Greenfield, would that be okay to transfer all that information to her, or?
All right, now what did you say?
Sorry. I have a probation officer in Greenfield. Okay. I don't know if that's what you...
Well, you just sit back and let me do everything, and then once I tell you everything, then if you have questions, you can ask. All right, so you will be under the pretrial supervision of probation department at 117 East Main Street. You'll be required to report to them immediately after your release. You'll be required to report to them once a week for 4 weeks after that as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse and mental health issues. Any treatments indicated, you enroll in and follow that during the pendency of this action. Now, you're also going to be under house arrest at your residence, except when you're going to and from work, medical appointments, court proceedings, appointments with an attorney, probation officer in this or any other case, containing any kind of schooling, job training, educational programming of any sort, or church. Other than that, you have to be there at all times. Now, you're listed on your financial disclosure form as homeless. Where are you going to be staying once you're released?
I don't know the address exactly, but I do know where I'm going, and it's going to be in Greenfield.
You just give that information to the probation department, and that's where you'll be required to be. Now, you can go to work, and you can look for work, but you have to report to the probation department when you're doing that, and they'll explain to you how that works. All right, we will notify your attorney of her appointment to represent you, and you can get her phone number and so forth from the clerk's office. You have any questions now, Mr. Wesselo?
No, I think everything would play out. So, good. Thank you.
All right, thank you. Case number 23, CR 157, State of Ohio versus Deandra Wilkerson. Present for the State's Assistant Prosecutor King. Present for the defendant is Attorney Catherine Hapner. And you are Deandra Wilkinson. All right, Ms. Wilkerson was indicted by the grand jury on a single count of aggravated possession of methamphetamine, a fifth-degree felony. I believe the matter may be set for trial actually next week. The matter has been set for a plea hearing a week or 10 days ago. We couldn't get it in because of the holiday and within the 14 days, so it was agreed it would be heard today. Ms. Wilkerson, I have a plea of guilty form here that says you're going to plead guilty to the charge, which is aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code, fifth-degree felony. And it states that you understand the maximum, the prison term for that could be between 6 and 12 months if one is imposed, and a fine of $2,500 and a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Now, this is a 3-page form, and on page 3 there's a sentence under which reads, I enter this plea voluntarily. Immediately below that appears to be the signature Deandra Wilkerson and plus the attorney's signatures. And do you recall signing this document?
Yes, sir.
And how long ago did you sign it?
Last week? Maybe
Okay, so a couple weeks or so. When you signed it, did you understand it's an agreement to plead guilty, which means there won't be a trial? The next step in the case will be sentencing.
Yes, sir.
And did you have enough time to fully consider the matter before making the decision?
Yes, sir.
And do you feel that you were rushed or pressured in any way?
No, sir.
And since it's been a while and you've had a couple weeks to reflect on it, is this still what you want to do?
Yes, sir.
Now, and did you enter into the agreement to plead guilty voluntarily?
Yes, sir.
Is that what you intend to do today voluntarily?
Yes.
Right now, the agreement, well, let me ask you this. Are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, if you are convicted, and if you should be sentenced to a term of imprisonment, upon completion of that term, it is possible the adult parole authority, as part of the sentence, could place you under what's called post-release control for a period of up to 2 years. If they do, you'd be supervised on the terms they set, and if during that period of time they found that you were not complying, they could then impose a sanction of a prison term of up to 9 months. Well, in this case, it's 1/2 of whatever term was imposed for one or more violations. But if you should commit a new felony, then in addition to whatever sentence a judge in that new case could impose upon you, that judge could also sentence you for committing that new offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence of the new case. Do you understand that?
Can we have justice?
Recording in progress. Recording stopped.
Thank you.
Okay. Now, did you understand everything I said about that post-release control?
Yes.
Okay. Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control, which is a term we use now to describe what most people understand as probation. That means that you'd be supervised under the probation department conditions as set by the court, be supervised under the conditions set by the court by the probation department. Could be for up to 5 years. If during that period of time they thought that you were not complying, they would file a written notice of that with the court, give you a copy, there would be a hearing at which you'd be entitled to have an attorney. If the outcome of that hearing was that you'd failed to comply, then at that time, the court could revoke your community control and then sentence you to incarceration between 6 and 12 months, fine you $2,500. You understand that? Now, the charge alleges that on or about April 6, 2023 in Highland County, Ohio, You did knowingly obtain, possess, or use a Schedule II controlled substance to wit methamphetamine in violation of Section 2925.11 of the Ohio Revised Code. And so that's the charge, a fifth-degree felony with the penalties I just described. Now, Ms. Wilkerson, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the charges in the case, the possible offenses in the case, possible legal issues, possible outcomes of a trial with your attorney? Are you satisfied with her advice and competence?
I think so.
Pardon me?
I'm sorry. I said I think so.
Okay. All right.
I'm not sure about that.
Okay. Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs that interfere with your ability to understand what's going on here today?
No, sir.
All right. Has anyone threatened you to make you plead guilty? On page 2, there are a couple of sentences that read, defendant will enter a plea of guilty to the indictment, state defense jointly recommend community control and referral to drug court. Other than that, has anyone promised you anything to get you to plead guilty here today? Okay, now under the law, the matter of sentence is up to the judge, not to the parties. And so even though both the state and you are recommending you get community control and be put in drug court, that's not binding on the court. So if you plead guilty, once I've heard all the information and reviewed everything regarding your case, if I decide that's not the correct sentence, you could be sentenced to a term of incarceration between 6 and 12 months, fined $2,500, and have your license suspended for 6 months to 5 years. You understand that? Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
Right now, I have I don't have my license at this time. I have a permit from Greenfield.
Now, I'm talking about driving. I'm talking about occupation, like a nursing assistant or anything of that.
I work at Greenfield Precision Products.
Okay, so that's all right.
It's a factory.
Right, okay. Now, you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have an attorney to represent you, and Ms. Hatner was appointed to represent you. Now, that wasn't simply for the purpose of working the case out, but to provide any defense that might be available to you under the law that you'd like her to provide. So, if you decide that you do not want to do this, she'll continue to represent you and defend you, including a trial, if that's what you would like. You understand that? And keep your voice up, please.
Yes, sir.
Okay. Now, under the Constitution, you have a right to have a jury trial in this matter in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 people are selected, the evidence would be presented, that jury would be instructed on the law, and then they would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case you would have what's called a court or bench trial, which means instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to try to bring out evidence that would help your side of the case. You understand that?
Yes, sir.
Under the Constitution, Ms. Wilkerson, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those people to come into court to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. You decide not to testify, the fact you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it during the proceedings, except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge till proven guilty by the state of Ohio on every essential element. That means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty, which denied the allegations, and the indictment denied you committed a crime and exercised or invoke all the rights I've just described. If you change your plea today from not guilty to guilty, that's the opposite of the not guilty plea. A guilty plea admits the allegation in the indictment that they're a crime and that you committed the crime. And that plea waives, gives up all the rights I've described for you today, except one, your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses or cross-examine through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal that you may have thought you had up until this point in the case. If you should be sentenced to the to the maximum sentence or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentence and entry being filed. Do you understand that?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
I understand.
Have any questions about the plea agreement?
No, sir.
You understand?
I understand.
And you understand the recommendation on sentences and binding on the judge? Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
I understand.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes, sir.
You have any questions first?
No, sir.
Now do you understand? Okay. Is there anything else you'd like to speak with Ms. Hapner about before we go any further?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this plea agreement that we've just gone over here today?
I'm sorry, sir.
Is it your decision to withdraw your not guilty plea and plead guilty today pursuant to the terms of the plea agreement?
Yes, sir.
Then, as to the charge which alleges that on or about April 6, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, a violation of Section 2925.11 Ohio Revised Code, the charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying possible term of incarceration of 6 to 12 months, fine of $2,500, and a license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. You can be seated. Court finds on this day, the open court defendant was advised of all of her constitutional rights and made a no intelligent involuntary waiver pursuant to Criminal Rule 11. The plea is accepted. Order filed. Defendant is found guilty of the charge, fifth-degree felony. Set forth in the indictment, the court orders a pre-sentence investigation, which will include an assessment for substance use and/or mental health disorder treatment. The matter is referred to the drug court docket as well for evaluation and determination whether Ms. Wilkerson would like to be admitted into that docket. The sentencing will be set for February the 14th at 1 p.m. All right, so you'll need to report down to the probation department and let them know that you've entered a plea of guilty and you need to get a PSI scheduled. And then they'll make an appointment also for you to talk with either Ms. Sturgill or Ms. Davis about admission into the drug court. All right, is there anything further from counsel?
Yeah.
All right, thank you.
Thanks.
I do apologize for
All right, this is case number 22 CV 212. Philip J. Wyrick et al. Versus Brandon Farms LLC. And Attorney Jess Weed is appearing on behalf of the plaintiff. And see, Mr. Bowman, you're appearing on behalf of the defendant, is that correct?
That's correct.
Okay. All right. And are either of you going to have any clients present for this hearing?
No, Your Honor.
Okay. All right. All right, the matter before the court was a motion by defendant to, for leave to file an amended counterclaim. The court set the matter for hearing. There were two as I understand it, Mr. Bowman, if I'm looking at this correctly, two things you wish to do is dismiss Ms. Drummond from the complaint, counterclaim, and then to add an additional cause of action against Ms. Wyrick only as to the RC 20, I forget what section number it was now. Hold on here a second. I'm having a little trouble understanding you. Let me get my volume up here.
2307-16.
2307-60. All right. All right. So I wanted to have a hearing so to determine what is the plaintiff's position regarding the amendment, Mr. Weed.
Well, Your Honor, obviously, we are not thrilled with the idea of amending the counterclaim. We certainly, although we're not admitting to any of the allegations contained therein, but if they believe that they have the evidence to back those up, we will consent to litigating them.
All right. Would there be any need to, basically you would just file an answer basically the same as before, just deny that additional claim. And discovery, is discovery, any additional discovery as a result of that claim necessary?
I don't know that we need particular discovery necessary because of the claim, Your Honor. Discovery was ongoing and we learned things which led us to need to amend our complaint, and that's all sort of tied up together. So I don't know that any particular kind of discovery needs to be done different than we've been doing. So.
And let's see, that would be the, let's see, in the amended complaint, which claim is that? The fourth, okay, fourth claim? Okay, so the fourth claim would be new.
Fourth claim is new.
And everything else would be the same except Ms. Drummond is deleted.
Yes, I mean, the factual averments have changed, but the causes of action are largely the same.
All right. Well, I note the original complaint, there was allegations that Ms. Wyrick had attempted to prevent the closing of it through the trustees, and that they went ahead and approved it anyway. And at this point, as I understand it, the commissioners have not taken any action. Is that correct?
That's correct.
All right.
That would be correct to my knowledge.
All right. All right, well, it appears to the court that since these allegations were filed originally in the original counterclaim and have been pending, that all it simply does is add the new legal theory. It doesn't really seem to change any factual allegations. So based upon that, the court will allow the leave to file the amended complaint dismissing Drummond. And I think probably make it clear on the record, in the written record, Mr. Bowman, it would be best to go ahead and file a voluntary dismissal, Rule 41, because even though it's in the complaint that she's deleted, there's not really been a motion to dismiss her as a party. So I think that'd be the best. So it goes in the file in writing, and anybody that looks at it can tell that she's been removed.
I believe we have already drafted that, Your Honor, and perhaps even filed it.
Okay.
I know. I'll speak that I got a copy of it.
Oh, you did get a copy?
I've got a copy of the 41A. Whether it got filed, obviously I can't speak to that, but I'll.
Well, with the week of last week being a holiday and everything, it's not in the file at this point. So if you could check online and see if it's filed, if it's not, send an e-file another copy there, Mr. Bowman. I'd appreciate it. And then 7 days enough for you to file your answer, Mr. Weed.
7 days from then, yes, I can get that done.
All right. Plaintiff will have 7 days to file your response then. All right. And let's see. I didn't have a chance to look at this, at the scheduling order in this case here this morning before we started, but when are we set for trial in this matter?
I believe currently we're set sometime in March, Your Honor.
All right, that's what I thought. Okay. Let me ask counsel. Okay, let's go off the record. Is there anything else counsel would like to discuss on the record?
I can't think of anything on.
No, Your Honor.
All right, we'll go ahead and go off record then.